All right. Protocol 25 CM 1068, State of Wisconsin versus Cameron Fossum. Appearances.
Ms. Fossum, are you available and can you hear me online?
Yes, Your Honor.
Thank you. Ms. Fossum appears in via video. Attorney Kathleen Chung is present in court. I have a copy of this criminal complaint. I am going to ask the court to review the criminal complaint. What I show here is that I believe an officer arrived to the
Sir, we're going to mute you until your case is called. Just 1 minute. We're doing a different case first.
I believe the officer arrived on the scene, saw injuries to the defendant, Cameron Fossum, did not observe injuries to anyone else, and then asked the defendant why she injured herself or themselves. So I'm going to challenge the complaint.
State.
I did respectfully on a misunderstanding of probable cause relates to a full client motion to dismiss. The complaint clearly says that, and I'm quoting from the middle blank paragraph of the largest one on page 2, that the victim stated this led the defendant to punch him. There's a lack of intent there's other information supporting the sort of conduct where that evidence can be co-terminus with both battery and third conduct. So I think there's plenty of evidence to support both of the elements of battery and disorderly conduct. Furthermore, I can't tell if the defense is alluding potentially there's some sort of argument that another perpetrator committed this, or that it was a self-defense argument. But of course, affirmative defenses are not relevant for purposes of a motion to dismiss.
And in that same paragraph, it does LRP stated that it was pain from being punched. Therefore, on the 4 corners of the complaint, your motion to dismiss that count is denied. Miss Fossum, is the best mailing address for you 3428 Valley Woods Drive in Verona, Wisconsin?
Yes, but it's going to change soon, and I do not know the address that it's going to change to yet.
Okay. As soon as that you know that address, and as soon as it gets changed, make sure you update the court, okay?
Okay, will do.
I have reviewed the criminal complaint. I do make a probable cause finding as to, I already said count 1. I will also make that as to count 2 and enter a not guilty plea on Ms. Fossum's behalf. State's position on that.
Your Honor, I'm asking for signature on the no contact with Lyric, Lyric, last name initial P is in Pepper.
Counsel.
I don't have any information on her qualifications, so I'll ask the court to advise her regarding public representation, and we have no objection to the signature bond.
I will then order a signature bond for Ms. Fossum. Ms. Fossum, I'll order that you have no contact with Lyric C. You can't call, write, text, no contact whatsoever during the pendency of this action. I will also advise you that you need to make sure if you want an attorney on this case, it's a criminal matter, you should apply to the public defender's office, see if you qualify. If you're denied, you can appeal that decision and go through further routes. We are adjourned on Ms. Fossum's case.
Just for big, did you say C or P for the last letter?
C.
Can I ask a question?
Yes.
Don't say anything about the case because there's a court reporter who takes everything down.
Oh,
briefly, I just want to make sure.
Okay. My car is at the location because we both live there. Am I able to get that, or how would I go about getting that?
You'll need to contact the police if they deem that it's a safe time to do that. After they do a lethality assessment, they may assist you in getting that car. If they don't go there with you to get that car, you cannot go there. You need to make sure the police will escort you there.
Very great.
Thank you, Your Honor.
Ms. Fossum, I want to give you the phone number for the public defender. Are you able to take that information since you're not present in court?
Yes, I can take that.
608-266-9150. Please contact them as soon as possible to seek an attorney, okay?
Yes, thank you.
We are adjourned in Ms. Fossum's case. Oh, yes, there we go.
Next case would be. Wait, looks like. Motion to draw the roll out.
Okay. You unmute.
So, yes, it's in from Student.
Not this.
We need a minute first before we can go on to the next case.
I think it's gonna take a while to unmute first, unless we can't teach it.
We can only request on mute. They still have to click something over there.
Mr. Peralta Maribel, from Milwaukee Secure Detention, if you're in there, could you unmute if there's an officer, someone in there, if they could unmute? Thank you, sir.
It's gonna be three. It'll be distributed by mail. Next, the list has even on bond forms. We had a new condition. That's the bottom. I have other subjects, but yeah, it's one. I don't think after that, it is do the substitution. Let's be already including this.
Can you guys hear me now?
Yes, sir. It'll be just a minute. We're just taking care of some logistics, but then we're gonna do your case next, okay?
Thank you.
That was over.
Thanks.
No, I say this.
Sure, that's important. Change your little bit. Oh, it's done.
No.
Change your little. Well, we get that change.
Let's make it. Hmm.
We're gonna go on handsome.
We'll call 25 CT 307, State of Wisconsin versus Joaquin Peralta Maribel, appearances.
Mr. Peralta Maribel, can you hear us?
Excuse me?
You can hear us?
Yes.
Thank you. Mr. Peralta Maribel appears from the MSDS in Milwaukee via video. Attorney Kathleen Chung is present. I have a copy of the criminal complaint and waive its reading. I don't have information about whether he qualifies.
Mr. Peralta Maribel, right now they've got the best mailing address as the Milwaukee Secure Detention Facility. Should we retain that as your best mailing address?
Yes, please.
I have reviewed the criminal complaint. I will enter a not guilty plea on Mr. Peralta Maribel's behalf after making a probable cause finding as to the charges. Mr. Peralta Maribel, this is a criminal matter. As such, you have a right to an attorney. You should immediately contact the public defender's office here in Dane County to see if you qualify for an attorney to represent you in this matter. If they turn you down, you can appeal that, and there's options they will give you in regards to that. State's position on bail.
Your Honor, I'm asking for a signature bond that the defendant not operating motor vehicle without a valid driver's license. Lastly, that you're not operating motor vehicle with any alcohol in the system.
Any objections, counsel?
No.
I will then order a signature bond for Mr. Peralta Maribel. I will order that you not operate a motor vehicle without a valid driver's license or after the consumption with any alcohol. We are adjourned. Good luck to you, sir.
I have some question. Can I?
Just don't say anything about the case. There's a court reporter who takes it all down.
Oh, that's fine. It's just the thing is that it's kind of about the case, but it's fine. They write it down.
Wait for your lawyer, sir.
It's an OWI second. It's an OWI second and a PAC second. But you got a signature bond on this case out of Dane County, okay?
I know, but the thing is that I was revocated on my probation for 21 months, and I'm trying to get this resolved as soon as possible.
Yep, you don't want to say anything about guilt or innocence. You want to make sure that you have an attorney represent you. Reach out to the public defender's office as soon as possible to get counsel appointed to assist you, okay?
We know where
I
you
don't think
are.
I can do that through here because the phone that I have here that I'm able to contact an attorney is only for Milwaukee County, I believe.
Okay, hold on.
Mr. Peralta Maribel, since you are in custody, the public defender's office will be able to reach out to you.
Nothing other than bond today, sir. This case is going to get set for another hearing.
You know what will be the next day?
We don't have that date right now.
Okay, thank you.
Good luck to you, sir.
Thank you as well.
Next up is gonna be Nicole Morris.
Speaking three.
I see y'all. Yeah, we're done.
It's packaged. Ready? Yep. Court will call 25 CF 1146, state of Wisconsin versus Nicole Renee Morris, appearances.
State.
Ms. Nicole Morris appears in custody in person with counsel David Anderson.
Good afternoon.
I have received a copy of the complaint. I do waive any further reading of that document. That's court to enter not guilty pleas to any misdemeanor counts, and the address is correct.
I have reviewed the criminal complaint. As to the misdemeanor charges, I will enter a not guilty plea after making a probable cause finding for Ms. Morris. State's position on bail.
State requests that your signature on no contact with an individual with a Cameron last name initial S as assault, and then you order no alcohol, no use of possession of alcohol.
Any objection, counsel?
No judge.
I will then order a signature bond. I will order that you have no contact with Cameron S during the pendency of this action, no calling, writing, texting, no contact whatsoever. I will also order that you not consume or possess any alcohol. Time limits in regards to the preliminary.
We will be waiting the time.
Those time limits are waived. A status conference shall be scheduled. We are adjourning Ms. Morris's action. Good luck to you. Thank you so much. Next up is going to be Adam Paul.
I give you all.
That's right.
It was about.
Was Nicole Hall?
Which one?
I have to do that. That's all. 25 CF 1142.
We're not quite ready yet.
Sorry, 1 second. It goes down here. Right.
I don't know.
First is
Yeah. You have to do it. Get the difference of that.
it is.
We're so divided. Super also. But then.
Doing him?
Yeah. No, that's not,
Yes.
isn't actually still. When you guys did this event. No. Go off about the regulars.
Oh,
Yeah, actually. Oh, they were a time. So.
I'm gonna put that in.
Yeah. I'm not where they stay at. So let's see. Large set up on many senses.
Yes.
They're digging up and stuff. Already.
Court will call 25 CF 1142, state of Wisconsin versus Adam Paul. Appearances.
Background simple state.
Afternoon, Your Honor. Attorney Stephen Mays appears alongside Adam Paul. Person of custody, we have received a copy of the complaint. The address is correct. We could waive a formal reading of it. Enter not go to the police to the and request preliminary examination of one the time limits and certain accepting status.
I have reviewed the criminal complaint. Did you make a probable cause finding as to count 2? I'll accept the not guilty plea entered on Mr. Paul's behalf. State's position of bail.
State requests signature bond, the defendant not operate a motor vehicle, that the defendant not use or possess any alcohol, and that the defendant not use or possess any controlled substances or paraphernalia without his own prescription.
Any objection, counsel?
To the not driving at all, he does have a valid license. Most recent prior was 13 years ago. He's got a license that he drives. You should add to it, not drive around on his own. No objection to the others now with this.
I will then order a signature bond for Mr. Paul. I will order that you not operate a motor vehicle without a valid driver's license. I'll order that you not possess or consume any alcohol whatsoever. I'll order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. Time limits are waived. A status conference shall be scheduled. We are adjourned in Mr. Paul's case.
I request what the date is from status, because generally Thursdays are not good for us.
The status conferences are always scheduled on Monday afternoons. If you decide that you want to waive a prelim, you can certainly write something in and have us waive it. If you decide,
That's
that you want to have it scheduled for.
That's fine, yeah, schedule some on Thursdays in the interim, but if they're Monday afternoons, that's fine.
Okay.
Thank you.
And generally, if there's an attorney that's on a case, nobody ever needs to appear for these anyway.
So statuses.
Right, that's what I was saying. If you decide that you want to waive the prelim, you can send something in, and if you decide that you want to have it scheduled for a prelim, you can send something in.
Understood.
Not really if they're not.
Understood. Thank you.
We're adjourning Mr. Paul's case to Lumpy said. We need to know this text.
IASTC. And personal signature.
When we are ready, we'll do Renee Waller.
Obviously.
Yep. Nope, I understand. So it's never thank you. I did it up above in the wrong place then.
I appreciate that I don't think it's clear that I like no, I just like to ensure that you are.
I put it up here.
Okay. Yes.
Okay. Sitting where I'm supposed to be, right?
Yeah. That's okay. That's fine.
Protocol 25 CM 10. Wait, no.
Oh my God, yes.
Right.
Spirit. My.
Here.
Protocol 25 CM 1069, State of Wisconsin versus Renee Waller, Yasham of Kansas.
Thank you. Ms. Waller Joaquim appears in person with Attorney Kathleen Chung. I reviewed the criminal complaint, will waive its reading. An address that we can use here today is 1926 Northport Drive, apartment 26, Madison 53704. She qualifies for public defender representation. And will stand mute and enter not guilty on the misdemeanors.
I have reviewed the criminal complaints. I do make probable cause findings as to all misdemeanor charges and entering not guilty plea on Mr. Waller Mule's behalf. State's position on bail.
Your Honor, before the state speaks, it's my understanding there's a victim, Brian T. is in town, would like to make a statement.
Brian T, you're currently, now you're unmuted. Can you please spell your first and last name for the court reporter?
Yeah, my name is Brian Torres Feliciano, Brian, middle name Luis Torres, TorresFeLiciano.
Thank you, sir. This is your opportunity to tell the court what you think I should do in regards to setting bail here today.
I spoke to someone about like my request, but I was more hoping like I read off with the no contact situation. If it's could be deferred or either dropped due to the fact that we have just children involved, just in case she does get released. Where if she does get released, she can still have contact, just do with the children. I know she wants to be still apart, and I think that's my main concern. Just with that. And
So you don't want contact, but you want her to be able to have contact with the children. Is that what you're requesting?
yeah, however is best worked out. It was more if like however it's easier with the no contact situation. If it's dropped, that'll be easier with talking. I spoke to them and I told them that I agree with other things. And I also voiced out and sent a letter in saying that if it was easier for her to return home, that maybe if I could receive some type of support for myself and my children to find a different location in the meantime. So that could be proper, just like co-parenting, but I do believe like space is needed, like from each other. I just, yeah.
Thank you, sir. The court appreciates your comments. I'll take them under advisement and setting bail here today. State's position on bail.
Your Honor, the state's asking for a signature bond, no conditions, including that the defendant not use or possess any alcohol. That the defendant not have any contact with individual named Brian, last name T's and time. And that the defendant not be at 1345 Williamson Street in Simpson. Your Honor, just briefly support the state's argument. It's the state's understanding this is the defendant's the defense had multiple referrals of allegations of domestic violence, domestic conduct, and the defendant always appears to be the aggressor in terms of the referred charges. These individuals, as the victim attention, have a family, they have young children. The defendant is alleged to have put essentially the victim in a chokehold around the victim's neck. So these are pretty serious allegations, and given the history between these individuals, no contact is appropriate. Thank you.
Thank you, counsel.
Thank you, Your Honor. She has no objection to those conditions, but given the fact that there are small children and the statement of the victim, we're going to ask for third-party contact support to permit child contact, to permit some kind of contact with the children.
I will give Ms. Waller Yocum a signature bond. I will order that you not use or possess any controlled substances or drug paraphernalia during the pendency of this action. You have no contact with Brian T. That you not be at 1345 Williamson Street. And I will allow for third-party contact with Brian T in regards to child placement custody issues that need to be addressed.
I just want to make sure the state asked for no alcohol. I think the court's already no drugs.
I did that you not use or possess any alcohol during the pendency of this action. It should be alcohol, not drugs. I apologize. We are adjourned in Ms. Waller Yocum's case.
Thank you. When we're ready, next up would be Ryland English, appearing by Zoom from the jail.
So
Oh, I know. Thank you. Well, that's what I have.
Don't read it, so that makes sense. Let me see word.
And I got that's yes.
That's good.
Okay. Well, that's should be.
That same motion.
You might be on Zoom.
Do we have it?
Yeah, the slide I can't see.
Is Ryland there? Oh, there we go. Okay. All right. Court will call 25 CF 1086, State of Wisconsin versus Ryland English appearances.
According to the state.
Ryland English appears by Zoom in custody at the Dane County Jail, and Attorney Paisley Hoffman appearing at the CUGAF as well.
Good morning. The address on the criminal complaint is 1729 Heim Avenue in Madison, Wisconsin. Is that your best mailing address, sir?
Your Honor, his best mailing address will be the Dane County Jail.
We'll move that to the Dane County Jail for now purposes. I have reviewed the criminal complaint. It alleges one felony charge. State's position on bail.
Your Honor, the state's requesting $5,000 cash. No other non-monetary conditions. This grounds the defendants on pretrial custody and significant homicide case. It's like it's a result of his death. Here the defendant's engaging in additional violent behavior contrary to the rules of the Dane County Jail was a felony. And so I think the additional charge is based on.
Counsel.
Thank you. I think this is somewhat of an academic argument, given that Mr. English is sitting on $100,000 bail in his other case. However, I do believe that considering the statutory factors, his limited history, that homicide is just an allegation. He has no history of missing in court. That a signature bond would be appropriate in this matter, given those facts. However, as I stated at the outset, it's purely academic because he's not gonna be able to post the other amount.
Given the violence that's alleged, the charges against him, and the situation, I do believe that some cash bail is appropriate. I'll set cash bail in the amount of $1,000. Time limits for the preliminary hearing, counsel.
We would waive the time limits. I have a signed waiver already that I'll file once soon as I get into my office.
Time limits are waived. They'll get first set for status conference or ultimately arraignment after that. So see. Great. Thank you, counsel. Have a good day.
It doesn't, it goes down. Maybe both days on.
There's nothing else to do. We're not sure if I leave was actually the shitting side of British Falls.
I was told no, but I'm. That's, oh, I just. It should have said yes.
Hold on. We'll call 25 CF 895, State of Wisconsin versus David Odell, appearances.
Thank you. Mr. Odell appears in person. The correct address is on the complaint. He's here based on a PTS report. And he did not appear, it looks like, on May 5th for court. It looks like the warrant was issued on May 3rd. And he was not aware of the May 5th date. It makes sense that it's possible that because I think the 30th was, so that would have gone over a weekend. So, but the real issue here is the violation of the conditions that were set. I think the court knows that, and based on the complaint, I'm looking at a pretty high BAC here. So this is obviously due to a disease, or at least that seems likely here. The allegations that is the reason for the bench warrant is not conduct that would otherwise be illegal. There's no allegation here that he was driving or doing any other dangerous conduct. Of course, the conduct is the violation of bail and he shouldn't do it. But it is a conduct that he probably is, if it is true, is dealing with due to a long time, or at least a very, not necessarily a voluntary issue. I'm going to ask the court to take that into consideration and not impose significant. Certainly, this is issued as a body only warrant. I think some small cash may be appropriate here to allow him to try to deal with this.
Looks like there was two violations. The first violation led to a $500 cash bail order being posted. He posted it and promptly violated again, which led to the newest warrant and also led to the failure to appear then to address the previous violations. The state's position on bail.
I'm trying to do this as simple as possible. I heard factual recitation, Your Honor, that we ordered $1,000 warrant. I think $1,000 after the previous 500 already been forfeited. $1,000 is an appropriate amount of that, so you can post that.
Briefly, Your Honor.
Go ahead, counsel.
He can't post it. He'll be in custody. He won't be able to post that. I understand that for the state's position. I mean, they don't want him to violate bail. They do want him to stop drinking, but to deprive him of his liberty because he can't beat this dead. In other words, that he cannot stop this disease on a dime is not just.
I think there's more to it than that. There was a notice sent out of an appearance that he failed to appear. So not only are there numerous new violations, there's also the failure to appear. Given that, I do believe that cash bail is necessary. There's a sure appearance at future court dates. I will set cash bail in the amount of $650, and I will reinstate all non-monetary conditions. We are adjourned in Mr. Odell's case.
Basic conditions that will remain under the control service number and any different tax because it's in the signature bond. So yes, I'm gonna do this if they fail services. Boarding from more that and so we need to schedule for that ways. And then
Next up is Laurent Smith.
no. I don't even. Well, I'm saying I'm the ones.
Wait a minute.
Yeah, there you go. So I'm just.
Roll call 25 CM 1067, State of Wisconsin versus Laurent Smith. Appearances.
Frank Remington out of the city.
Thank you. Mr. Laurent Smith appears in person. His correct, with Attorney Kathleen Chung, his correct address is 2745 Yahara Road, Madison. That 53704.
85.
I'm sorry, it's Stoughton, Wisconsin. 53585.
53589?
Yeah.
Yeah. That's their apartment number?
Nice house.
Thank you.
He's eligible for public representation. We have a copy of this criminal complaint and waive its reading.
I have reviewed the criminal complaint. I do make a probable cause finding as to the misdemeanors and enter a not guilty plea on Mr. Smith's behalf. State's position on bail.
State requests $500 cash bail and no contact with David B's and Beef banned from Sub-Zero on Fitchburg, Wisconsin. The defendant has failed to appear in the past, most recently in March of 2022. The defendant at the time of offense and these allegations was on supervision with imposed state prison time, home number said. So the possibility of relative to these charges, significant incarceration is much higher than the average case. Based on that, I think $500 is appropriate as well as the non-monetary condition that I already for. I think it's
That's even nothing. It's like. Center PTS 3. Is that?
Yeah. Mr. Smith is on a Department of Corrections hold. He's asking you to ask for a signature bond on this case. He indicates that since then he is not misreported. If he is on supervision on the Department of Corrections agents, he does release him, whether to an ATR or otherwise, he will be monitored, of course, by the department. I'm asking the judge or the courts to defer to the Department of Corrections while he's on supervision, allow them to decide whether he needs a bracelet or other more robust supervision. We'll ask for a signature bond.
Upon review of the criminal complaint, Mr. Smith's history, I do think some cash bail is necessary to assure his appearance at future court dates. I'll set it as low as possible at the amount of $200. I will order no contact with David B during the pendency of this action. We are adjourned in Mr. Smith's case.
Commissioner LeBan from Sub-Zero.
Oh, and I order a ban from Sub-Zero. Thank you. We are adjourned in Mr. Smith's case.
So we'll do it this one.
When we're ready, we'll have Raven Johnson appearing by Zoom from the jail. The bailiff there tells me that because of this particular housing area, it is starting to see and that she's not going to walkers right now. My sister and I here with her from the jet result. What's that? Thank you. So she's over in the city county building right now. Okay. So if that is, how she do her at the end.
If you want to hear and go in there and talk to her by Zoom, you can do that. Whatever takes some time and talk by Zoom.
Sure, whatever's most convenient. You guys, do you want to do that now or do you want to do that now?
We can do that now. We can do some ordinances while you're. Sure.
Reference, correct. We have to stand the all as we said.
Court call 25 CF 1147, State of Wisconsin versus Pierre Ruffin, appearances.
Frank Graham, keep those state only jobs. Yeah.
Thank you. Mr. Ruffin appears in person with Attorney Kathleen John. The best address to send mail for him is the Job Center, 1819 Aberg Avenue, Madison, 53704. He's not eligible for public representation in this case, but we have received a copy of the criminal complaint. He has one as well, and we'll wait its reading.
I have reviewed the criminal complaint. I do enter a not guilty plea after a probable cause finding on count 2 on Mr. Ruffin's behalf, although he's been given information regarding counsel and state's position on it.
State requests $1,000 cash bond of the defendant not operating a motor vehicle, that the defendant not use or possess any alcohol, and that the court consider ordering pretrial services with remote threat monitoring. As grounds of which one of these counts is an Act 3 offense, the defendant's alleged driving behavior was a serious danger to other motorists and multiple law enforcement officers in this case. There are multiple victims in this case. The defendant, instead of cooperating with a relatively similar WI investigation, engaged in fighting and other inappropriate, resistant, violent conduct with law enforcement officers. So the state believes that the monetary recommendation is appropriate opinion.
Counsel.
Thank you, Your Honor. We're going to ask the court to impose first consider, of course, a signature bond and then low cash. My understanding is this is Mr. Ruffin's first offense. There is an allegation here. Of course, he is not guilty of that allegation. He's considered innocent to go to court. The allegation here is that he was driving and that the officers pulled him over. There's an allegation that another driver reported him as, quote, all over the road, but there's no specifics. There's no indication of speeding. There's no indication of an accident. So I'm not 100% sure what the state is meaning about threats to the public. There is allegations of aggression with officers, but that's, so I'm not sure what other threat to the public is present here, other than the allegation of intoxicated driving. So I'm going to ask the court to consider first a signature bond. There is the driving on the belt line that's referenced, but we're asking the court to consider first a signature bond and then low cash in this matter. There's no allegations that he missed court. He is also, since he doesn't qualify, going to have to come up with funds for counsel as well. So we'll ask the court to consider low cash.
Given Mr. Ruffin's lack of history, as explained to the court, I hear nothing that he's got prior failure to appear, prior convictions, or prior criminal actions. I will allow him to appear on his own behalf. I will give him a signature bond. I will order as conditions of that, sir, that you do not operate a motor vehicle without a valid license, that you not use or possess any alcohol during the pendency of this action. And I'm not going to order pretrial services again, given the lack of history of Mr. Ruffin as presented to this board. Time limits in regards to the preliminary hearing, counsel.
Waived.
Those are waived. A status conference shall be scheduled. We are adjourned to Mr. Ruffin's matter. Good luck to you, sir.
No. We're on with Raymond Johnson, so we'll go to break out. So break in that.
These should be the of these. And it was he said that's lot.
Good job.
All right. Break this way, that's here. So we're getting.
Give me that.
Court call 25 FO 817 Dane County versus Tevin Newell. Appearances.
Frank Remington for this state/county, the defendant appears in person, you can go speak with our counsel.
Mr. Newell, I have some considered good news. The police department referred up criminal charges against you. The DA's office reviewed those reports and decided not to charge you criminal. Instead, they charged you with ordinance violations. In this case, they're ordinance violations for county possession of THC and county obstructing/resisting an officer. These are citations. They're not criminal charges whatsoever. If this is the only thing holding you in jail, no matter what you plead to it today, you're going to get released. Sometimes this is a case that can be resolved here today. What is the county's offer for resolution of these ordinance violations?
Your Honor, either one of them for court costs dismissing.
I think the minimum for count one is $1 plus court costs set by the county court, so that'd be $138.76. Count two, the minimum is $0. That'd be $114.50. So I suppose count two would be slightly cheaper. At
If you wanted to plead count two, which would be a better deal, you have 114. I find you guilty. Assess court costs only, which total $114.50. That'd be on the county resisting obstructing ticket. I would dismiss the county possession of THC. You'd have 60 days to pay. If you want to plead not guilty, that's absolutely your right, and the case can get set for further proceedings. How would you like to plead to count two of county resisting obstructing?
May I ask a question?
Yes, sir.
Second, how can you be able to post person?
If you plead to count one, that's the county possession of THC, there's a $1 fine that's mandatory. And then adding court costs, that one comes to $138.76.
Yes.
Show them my back.
It's going to show up as an ordinance violation, and it's going to show that you were convicted of whichever one you choose. And it's, when I say convicted, it's an ordinance violation. It's not criminal. So if you want to check into that before you make your decision, that's absolutely your right. We can enter not guilty plea to figure that out.
Okay, about told not guilty, then I gotta get out a little while.
If this is the only thing holding you, you're going to get released no matter what you plead on this case today. If you have a probation holder, you have something else that's holding you, that's going to remain. But this case is not going to hold you no matter what you. I'll enter a not guilty plea. This case will be set for further proceedings. Good luck to you, sir.
It's okay. So
Now we're going on it down and three goes down.
Oh, works. Court call 25 CF 1141, State of Wisconsin versus Raven Johnson, appearances.
Ms. Johnson appeared by video from the city county building for Attorney Kathleen Johnson present in court. The correct address for Ms. Johnson is Salvation Army, 630 East Washington Avenue, Madison, 53703. I do not know whether Ms. Johnson is eligible for public representation or not. We do have a copy, or I have a copy of the criminal complaint and will waive its reading. I don't honestly know whether she has a copy.
I will say that we did take a break so that Attorney Chung could meet via Zoom with Ms. Johnson. They had a meeting prior to coming in today, and Ms. Attorney Chung, you're prepared to proceed in regards to this initial appearance here today.
Yes, I did review the complaint with her, but I don't know whether she's got a copy.
And in regards to an attorney, Ms. Johnson, this is a criminal matter. As such, you may qualify for a public defender to represent you in this matter, and should definitely apply to the public defender's office to see if they turn you down. You can follow further steps to retain counsel or have counsel appointed. For today's purposes, Attorney Chung is going to represent you, and I have reviewed the criminal complaint. State's position on bail.
No objection.
Signature bond is ordered for Ms. Johnson. Time limits.
Wait, please.
Those are waived. A status conference shall be scheduled. We are adjourned in Ms. Johnson's case.
And the bailiff did provide her with a copy of it.
And for the record, we've just been informed that the bailiff did give Ms. Johnson a copy of that complaint. Thank you very much, everybody. We are adjourned.
It's either
Well, good afternoon. We still have some few kinks in the system. I'm not sure if I can shut off the live chat under this current configuration. But it does look like I have more control back of my Zoom and YouTube applications. As I advised when we got back from the judicial conference on Monday, they had changed the computer towers and we had a lot of logistical problems getting reconfigured, entering old passwords, reconnecting things, getting the microphones straightened out. So I think we've mostly done that. Hopefully you can hear me, but I can't see the live chat. I also can't turn it off. We had some office matters this morning. We didn't have any court scheduled. I would have done what I'm about to do, which was the jail and bail arraignments. And nobody was ready this morning. The paperwork hadn't been all completed from the prosecutor's office and submitted. So except for 2:30 this afternoon, and they're about to bring the defendants in by Zoom from the jail. We had a judiciary committee meeting at lunch, and I had a personal protection order hearing with our friend Reggie King. There's a federal statute that says personal protection orders aren't supposed to be publicly shared, so we don't live stream those. And Mr. King was quite subdued, acknowledged violating his personal protection order by going somewhere he wasn't supposed to be. And I gave him 46 days credit, 46 days. He has 2 other matters yet to be resolved, but that what I was fearful would be a contentious PPO hearing was quite uncontentious. The defendant acknowledged the violation. I sentenced him to time served and the matter was completed. We now have 5 jail arraignments, 4 arraignments and a waiver of extradition scheduled for 2:30. And the jail has yet to connect and the public defender isn't here yet. So I'm here. And I can't see the live chat. Mostly people were appropriate in the last day or so. So I don't have complete management of the system back. I had to wait 24 hours to get completely logged in. I'm not sure what that was about, but anyway, we're back and we will conduct this business. I certainly have had time to do it. Tomorrow morning, we have an arraignment day that was like our old arraignment days where there were 20 plus people. But they combined last week's Thursday arraignments with tomorrow's Thursday arraignments. And I think we have 22 misdemeanor arraignments tomorrow morning beginning at 8:15. Almost all of them are driving without a license type offenses with some other stuff like no insurance and no plates. So we're going to be busy tomorrow morning. We have some final pretrials in the afternoon. Friday will be a civil day with landlord tenant motions and some other things. So I guess we're back on track. Here's our public defender, Mr. Stickley. Turn the record on. Good morning or good afternoon, Mr. Stickley.
Good afternoon, Judge.
I think we've got everything we need here. I wanted to do this morning, but I had time about 10, but everybody else wasn't lined up. We have a waiver of extradition with Mr. Trampus Ritchie, who I just talked to yesterday. Had I known what I know now, I would have just taken this waiver at the same time. He told me he had a case in Indiana, but I didn't have the waiver, so we'll do that. That'll take just a moment. Then we have a couple of other matters, and we'll see. I called the jail about 8 or 9 minutes ago, asking for my inmates, and we'll see. Here they are. As you heard, we had a lot of logistical problems with the new computer installation. And I don't think we've completely worked the bugs out yet. I think the live chat is on and I haven't been able to turn it off, so we'll hope for the best. The logistics of moving, if and when they finally start the construction, this give me the shivers. Disconnecting every piece of audio video equipment, disconnecting every computer, every speaker, reconfiguring it somewhere else.
It only took 2 years after COVID to perfect the audio quality, so hopefully it doesn't take 2 years to bring it back.
Yeah, so we're still working on it. Good afternoon, Mr. Abel.
Good afternoon.
Of course, I know you. I'm Judge Middleton, and with me is Mr. Keith Stickley, the Chief Public Defender.
Okay.
You're here for an arraignment in a bail setting. This is the original arraignment. Usually it's done by a magistrate, but you're stuck with me today.
Okay.
Your Honor, it is tradition. I apologize.
Yes, I'm sorry.
I
Go
didn't
ahead.
mean to overspeak. Your Honor, usually traditionally on these, because of some bond discussions that we might have, I break out with them very, very briefly before we go on the record. Would that be acceptable to you today?
Oh, yeah.
Sure. I think we can do this one. I know Mr. Abel. He used to live across the street from me, and I'm going to give him a PR bond.
Okay. Thank you, Your Honor.
And, but in the others, that may be appropriate.
Thank you.
Anyway, we're on kind of a abbreviated calendar here. Anyway, you're Harold M. Abel III, is that correct?
No, just Harold Abel III. No M.
No M. And everybody knows you as Skip.
Skip, yep.
You got arrested for carrying a concealed weapon while you were intoxicated.
Okay.
The charge is a misdemeanor punishable by up to 93 days in jail and a fine of up to $100. According to the affidavit and bond information, someone called the central dispatch indicating that a man was passed out in his car and they thought he was in distress at your apartment complex. They found you in the car, quite incapacitated, and there was alleged to be a gun in the door handle. It is a 90-day misdemeanor. You've been in jail now for 2 days for reasons I don't completely understand. The paperwork wasn't completed. Are you still living at that address?
Yeah. Yeah, 1200 West Broadway, apartment 28, Three Rivers.
Now you're retired, is that correct?
Yeah, I did retire, but I'm still working. I'm actually out at Fisher Lake tearing a deck apart, so.
Oh, so you're doing construction?
Yeah.
As far as I could tell, Mr. Abel, I didn't see any criminal history whatsoever. And I'm not sure what was going on. Your blood alcohol was 0.157. And you were asleep in your truck and you had a gun in it.
Yeah.
Scary thing is you didn't materialize there. You probably drove there from somewhere else, but you're not charged with driving while intoxicated or anything.
Right.
My recommendation to you is that you plead not guilty to this charge and that I appoint an attorney to assist you, set it for a pretrial. Is that acceptable to you?
Yes, it is.
All right, I'm going to insert some bond conditions. This is scary stuff. According to the thing, they put you on a gurney and hold you out of there, and I'm not sure what was going on. But as a condition of your bond, you're not to consume any alcohol or any controlled substances. You're to not possess any firearms. Do you have any other firearms in your apartment?
I got one locked up, yes, that I've had forever. It's
Well, that's
registered.
gonna, yeah, so was the one that you were in the car with. That's gonna have to. And you're to surrender your CCW permit to the court. No assaultive or threatening behavior. I'm not gonna order testing, but
And I got super dehydrated that Monday.
Let's not bring that
Don't
up
say
right
more
now,
about
sir.
it.
Yeah.
but super dehydrated doesn't count for 2 times the legal limit for alcohol. So like I said, you're not charged with a driving offense, but you're not a flight risk. You don't have any criminal record.
No.
You've lived here all your life. You didn't do anything assaultive or threatening with this gun. I'm gonna set the bond at $500 PR.
What's that mean?
Personal recognizance, meaning you don't have to post any money.
Okay,
All right, now, so you're gonna get out of jail here in a little bit.
okay,
Bond conditions as listed. I'm going to show a plea of not guilty. Going to appoint an attorney.
okay.
I'm gonna set an attorney pre-trial. I think for June 20th. Hi, when are Judge P's attorney pre-trials? In June? All right, thanks. Okay, bye. I'm gonna set this for attorney pretrial for June 20th, 25 at 8:30. That'll be in front of Judge Pattison.
Okay.
It's probably better that way. And so we're gonna give you some paperwork that says an attorney is gonna be appointed. I want you to call that attorney, make an appointment to talk with them prior to the 20th of June. And that hearing will be live here at the courthouse on June 20th. All right, no alcohol. They can ask for a test if they wish. No assaultive behavior and no firearms. So you need that firearm needs to be, to have your wife take it to somewhere. And you gotta submit your CCW permit to the court till we sort this out. All
So
right.
maybe take it to Three Rivers,
What's that?
take it to Three Rivers Police Station.
That would be sufficient.
Okay,
Okay. You're gonna get out. Your wife's probably been worried sick about you in there for a couple days, but you're gonna get out. You'll be out soon. Somebody can come pick you up.
okay,
We have to sign this bond form. All right. You'll see Judge Pattison from here on out, but good luck to you.
okay.
All right.
So we're
You're
getting
good
the
to go.
paperwork out here?
Yeah, they'll fax it out there in a minute.
Okay, all right.
All right. You're good to go.
Thank you.
Okay.
I got 60 seconds.
Yes. Good afternoon, sir. Are you Mr. Trampus Ritchie?
No, I'm Jesse Wade.
All right. Well, I wondered. I just saw Trampus yesterday and I need to see him again. All right. You're Jesse Lee Wade, is that correct?
That's correct.
All right, let's talk about your case. The file number here is 25899FD. I'm Judge Middleton, and also here with me is Mr. Keith Stickley from the Public Defender Office, and I'll let you talk to him in a minute. The allegation here is that you were operating a motor vehicle on May 12th in the village of Constantine while you were intoxicated. Commission an aging parking lot. As a third offense, that is known as operating while intoxicated, third offense, which is a felony, punishable by up to 5 years imprisonment and a fine of up to $5,000. Carries 6 points on your driving record and requires your license be suspended. You're also charged with driving with a suspended or revoked license and being a second habitual offender. In that way back in 1996, you had a felony in Kosciuszko County. Theoretically, would make the punishment for this a maximum of 7.5 years. Because it is a felony, I have to set it for a preliminary examination. And we'll talk about that in a minute. The other thing I have to do with this proceeding is set your bond. And before we get into that, I'm going to let you speak privately in a breakout room with the public defender. And then we'll come back and address that. So I'm going to set up a breakout room. The button should come up and say join. It'll either join you automatically or you need to click the button. I think it does it automatically from the jail.
You ain't got a button, so.
Yeah, there he goes. As I indicated, these are most often done by the magistrate, but he's on family leave and he was in here today, but we're happy to help cover these. I have time to do it, at least today. World's most boringest live stream.
Your Honor, you might have to bring them in manually. I'm not sure that it.
Yeah, I believe I do. I changed the timing so I can shut it in 30 seconds rather than a minute. Nope, damn it. We redid everything. So now it's back to 60 seconds. I have to reconfigure that. We'll have to wait a minute. I was so proud of myself when I had some help, figured out how to do that.
Well, in our latest update, they changed the location. So if you need help, I'll drop in tomorrow and show you. I had to show Luke.
Change our location for what?
Where the 60-second, the countdown thing was.
Oh.
At least on ours when we got a software update. I don't know if you got the update or not. But.
I had a whole new computer update, which I'm still dealing with. We got the sound worked out. That was half the battle. All right, Mr. Wade. Because this is a felony, I'm going to set a pre-exam conference for May 27th at 8:30 and a prelim if needed for 6/3 of 25 at 1 o'clock. We'll appoint an attorney. I believe it will be Tim George, appointed by the public defender.
Okay.
All right, you're in custody on this charge. According to the bond information sheet, this happened in Constantine on May 12th, 2 days ago. The officer was Officer Andrew Hall from the Constantine PD. Your convictions are old. To be charged as a first offense drunk driving, it would be a misdemeanor. If you have 2 convictions within 7 years, it makes it a misdemeanor punishable by up to a year in jail. And if you have 3 in a lifetime, they charge it as a felony, which they did here. As far as I can tell, you weren't doing anything except driving with no seatbelt. And I tell everybody, if you're driving around with a suspended license, wear your seatbelt. It's an invitation for the police to pull you over. Now, I show your address in one place is Michigan and another place in State Road in Bristol. Do you live in Indiana or Michigan?
Yes, Bristol, State Road 120.
Are you employed?
Right now, I'm in between jobs, but I'm helping my 91-year-old grandmother and my dying mother. So I've been working at home and doing side jobs whenever I can.
Are you on probation or parole anywhere?
No, I'm not. No, I'm not. I've not been in no trouble in almost 20 years.
And you're not on bond in any other jurisdiction?
No, Your Honor, I'm not. Yeah.
All right. Also refused the test. Ms. Davis gave me the heads up on this. I saw it myself yesterday. I thought, well, I wonder if this guy's a candidate for sobriety court. Probably not if you live in Indiana. You have 2 prior offenses. Your driver's license was suspended. You're an out-of-state resident and you're presently unemployed, and you refused the breath test. But what this essentially is an OUIL guy who got pulled over for no seatbelt at a 147. I'm going to set the bond at $250 cash or surety. That's for the 2 priors for refusing the test. I'm declining a PR bond, but they used to set bond at OUIL thirds at $50,000 cash or surety under the theory that maybe they should all just sit till we sort this out. So it is a 3rd offense, but your 2 priors are old, 2006 and 2007. In fact, I don't think you even paid off your fines and costs from 2006. But I'm going to add some conditions to your bond. No drugs and no alcohol, including marijuana. As a condition of, I'm not ordering, you shall not operate a motor vehicle. Your license is suspended under the influence of alcohol and no driving. When you get out, you're not to have any assaultive or threatening behavior, no weapons, and you contact the community corrections office. I think we'll try to set up some testing. In the meantime, we may have to do it in Bristol. But your next court date is 5/27. Do you believe you'll be able to post a $250 bond?
No, I will not have the money, so I'll just have to take my time, Your Honor.
If you're still there by Friday, I'm going to change it to a PR bond. But like I said, you have 2 priors, you have a suspended license, you live in another state, and you wouldn't take the test. So I'll keep an eye on it. But right now, the bond is $250. This is a felony. So that's a very low bond for a felony offense. And if you can't post it, then maybe there's a reason for that. Anyway, that's an unusual bond for an offense like this. But because it is a felony and the reasons I stated, I was unwilling to do a PR bond. We'll see. Your next court date is May 27th at 8:30. All right, Mr. Wade, we'll send that paperwork out to you. If you do bond out, you gotta check in with the community corrections office. All right, good luck, sir.
Thank you.
You're good to go, Mr. Wade.
Okay, thank you.
I don't like this configuration very much. I'm gonna work on it. He's got droopy drawers.
Must be seeing something I don't see.
He walked out, he had a sag going on the way up the door. And is all over these. There's no sense to have that camera on.
Okay.
As I indicated, one of these is just a waiver of extradition. And if I know what I know now, I saw Mr. Ritchie to take care of an old unpaid ticket. And, but I didn't know about this. I don't think it had actually made it here yet. Good afternoon, Mr. Ritchie. This is Judge Middleton once again. Are you
Yes, sir.
Trappist J. Ritchie?
Yes, sir.
I just saw you yesterday and I didn't
Yeah.
know about this matter. I would have dealt with it then. It is an extradition matter. You're wanted in the county of LaGrange, state of Indiana, on a charge of delivery or possession of methamphetamine. You told me about this yesterday, that you had a hold on you from Indiana, and apparently we're done with our charges here in Michigan. I wiped out some of your time with that case we did yesterday. I gave you time served and wiped out the fine. In this case, you're wanted in the state of Indiana, and I'm told that you're ready to go back. So
Yes,
let me
sir.
read you the language. I, Trappist J. Ritchie, I am wanted in the state of Indiana. I waive the issuance and servance of a Michigan governor's warrant and all other procedures incidental to extradition proceedings, including the right to an attorney unless I already have retained one. I voluntarily agree to the demanding state, in this case Indiana, in the custody of an agent of that state. And you agree to do that?
Yes, sir.
Very good.
Yeah, this ain't gonna mess with my, cause I'm trying to, I mean, Swift and Sure knew that I was trying to get that I had a warrant or whatever, and they I was trying to get into Swift Insure here.
Well, I think Swift Insure is a good program. Problem is you can't get in a program while you got an open warrant for you from another state. So you might as well go take care of this and see what the deal is.
This is for, I guess I missed a court date or something, so.
Yeah, that's what you told me yesterday. All right, they'll send this out there. You'll sign it. And I imagine either later today or maybe tomorrow, you'll be taken back to LaGrange and you can deal with your issues there.
Thank you, sir.
All right, good luck, sir.
Thank you. Is that it?
That's it. You're good to go.
Thank you, sir.
Thank you. Like I said, I'm sorry we didn't do it yesterday. Both of these next two are a little tricky. Benjamin Lee Smith is charged with an unpleasant domestic violence second, but it happened a full year ago, May 24th of 2024. They, for reasons we'll explore, didn't serve the warrant for a year. The other defendant, Destiny Ford Morse, has been disconnected for 6 years. That happened in July of 2019. And she never showed up. She lives in Indiana. So one is a year old, one is 6 years old. And Miss Destiny Ford Morse was brought here from Hillsdale County. And I was suggesting maybe we ship all of our people to Hillsdale County, but instead of shipping them from there to here. So I'm not sure who we have next.
They have a pretty incredible overcrowding problem over there. I don't think that they could take anyone.
We were talking about that. You know, as you know, we were doing quite well. We started before we left for the conference at about 78. We were at 97 when the morning started. I'm just let 2 people go so far, possibly 3. We'll be back in the 80s. But there, we should count our own blessings. They got 1 prosecutor, no assistants, and a significant jail overcrowding problem and facility problems.
Hey, sir.
Yes, hi.
Does Richie need to sign this in front of you?
No, he can sign it. He acknowledged that he would do it, so he can sign it.
All right, thank you.
Thanks. But if I'd known you had it, I would have had him sign it, but he acknowledged that he did it. Thanks.
Branch County's renting space to everybody and their brother, so.
Well, I was talking with the Branch County judges at the conference, and yeah, their jail is significantly over capacity. That's a mixed blessing. Renting jail beds puts extra liability, extra work on your jail staff, generates money for the county. Calhoun did that also, built a very oversized jail. Ours is about the right size for our county, and I think we'll just take care of our own inmates.
It's only $35 a day there too, so I'm thinking of moving in.
Yeah, well, yeah, better than some of the nightly motels. Those people are paying $1,200 a month to live in a shabby hotel with a hot plate.
That's wild.
Well, $35 a night, that is kind of expensive.
Is it?
It's $1,064 a month. So I could probably find a nicer apartment than the St. Joe County Jail for $1,000 a month, but
you can't get a house in Colon for that. They wouldn't rent you a shed in Colon for it.
Why did he send this to me? Good thing we're not in a hurry. We're not bumping up against dinner time or anything. I got nowhere else to be. We dealt with our personal protection order matter on Mr. Reggie King, and it was quite uneventful. Mr. King was very polite, respectful.
Extradition.
I thought I did sign it.
Yeah,
But
it's the one that has
his signature on it. I thought he'd have him sign mine, not me sign his, but I think.
I get confused. They tell me.
Well, he had it there and I didn't realize that I should have had him sign it.
Thanks, Judge.
Thank you. As far as I could tell, the Marriott Hotel at the Renaissance Center didn't look like it needed to be torn down.
Oh, I forgot that that's where that was. It's not a bad spot.
No, I'd been there a few years ago for a wedding, but they did a nice job on it. It doesn't look threadbare or shabby or, so I'm not exactly sure what the total plan is for that plaza.
That tower, I don't think was ever going to be, that was the main tower. I don't think that was ever going to be touched. That was still sort of the crown jewel of the thing. Out of law school, when I got hired by Deloitte and I worked up there on the 35th floor. That was the only good thing about that job. We were overlooking the Belle Isle. It was amazing.
But you weren't in the big tower, were you?
Yeah.
The hotel tower? They had offices on those floors?
They did. Yep.
I think it's all hotel now.
No. There's, I don't know where the Marriott's in. Yeah. It's been a while since I was there, but yeah, 27th through 35th, I think, was all Deloitte.
All right. Good afternoon, sir. Are you Benjamin Lee Smith?
Yes, Your Honor.
I'm Judge Middleton. I've been asked to do your bail setting and arraignment here. Also with me is Mr. Keith Stickley, the Chief Public Defender. You're charged with domestic violence, second offense, 2 counts. I'm troubled by this, primarily that this is a year old. Let me tell you what the allegation is. Allegation is that on May 24th of 2024, you assaulted your son, Benjamin Smith Jr. There's only 1 count here as a second offender. No, there's 2 counts. Domestic violence second offense is a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. It's not eligible for a deferral. You had a previous domestic violence, I think in 2022 or something like that, that didn't go that well.
It was a management that I took the class and completed it. And also the CPS case that was open with me and my son, the altercation, that was already closed. Recommendations for me to get on medicine, mental medicine. I
Now that
personally
was
have.
back in 22 or now?
That was back when I guess I wasn't aware of this.
All right, well, this happened Now, before we get too far in the weeds, I'm gonna let you talk to the public defender. But as I indicated, this happened allegedly in May of 2024. And you're telling me that at that time CPS was involved and you did some other things as of last May?
Yes, that's what's, I'm confused why, I actually called, I was the one that called the officers yesterday to turn in a narcotic that I was slipped, and then they just said warrant for your arrest. And they tried to just have me sign some papers for a domestic I know nothing about. I was under the impression, I mean, my spouse can vouch on this, that I'm kind of in the dark about this.
All right, well, I'm a little confused too.
Me
So
too.
CPS was involved and the case was closed?
Yes, sir. I could go back to my home. He said, you know, I mean, this is,
Do you still live at Youngman Road?
no, we moved. We got a house, live at 617 South Hooker Road, Avenue, the Three Rivers.
All right. You have some other things on your criminal record, but as I indicated, this happened a year ago, and for reasons I don't understand, they never served the warrant. The prosecutor issued the warrant in July, 40 days after the fact, and then they never served it. So how did you get arrested? You called up and turned yourself in?
This is what happened. I had me and my spouse had a disagreement. I was supposed to go camping over the weekend. I went 4 days early. Unfortunately, when I went out camping, I had somebody that was trying to mislead me, was slipping me some drugs. I have proof of it.
I'm gonna highly suggest.
All right, but so anyway, you called
the
cops and then they found this old warrant for your arrest?
Sir, yes, sir. There's something that's going on that might need to be dealt with. There was pictures of a skeleton. There was narcotics that was presented to these officers, and here I am left in the dark. I mean, if there's some bigger thing going on.
All right, where were you when you got arrested?
Actually, I went to my mother's place on 616 Youngman Road, Lot 4. Right, so Travis Millerans went to turn in these pictures of a Skeletor to these officers. They asked who we were. Yes,
all right,
sir.
well, just a minute. I'm just trying to determine where you got arrested. So you got arrested here in St. Joe County out on Youngman Road?
Yes, sir. Yes, sir.
And so you, your wife and son are all residing together?
Yes, sir. We just got a new house. So I'm kind of confused what's happening.
All right. Are you on probation or parole anywhere?
No, sir.
Or bond?
No, sir.
All right. I'm going to put you in a private room called a breakout room where you can just discuss things briefly with Mr. Stickley. And I'll be here waiting for you. Just like Richard Marks or Brandy. We done?
Yep.
All right, Mr. Smith. My suggestion is that you plead not guilty and that I appoint an attorney for you. Is that acceptable to you?
Yes, sir.
All right, I'm going to appoint an attorney. I'm going to set the attorney pretrial for June 20th.
Thank you.
I would have set it for May 30th, but I don't think the attorney's available that day. So we'll go for June 20th. Are you employed?
No, I'm not. I had an LLC. Me and my work partner had a disagreement. I've been seeking employment. Actually, I am employed, but it's not a 9-to-5 job. It's doing yards and working for St. Joseph County on aging on folks that need help in their yard or their driveway. I'm available.
All right. How old is your son?
16.
And he lives there also?
Yes.
So this got referred to Protective Services. They provided some services and closed their case. Is that correct?
Yes, Your Honor.
Then you never heard any more about it until they
Just recently.
found this old warrant hanging around.
Yes, sir.
Mr. Stickley, what's your thought here?
Your Honor, considering the age of the warrant and the nature of being picked up, I don't believe on any sort of additional new charges, at least not that I've been made aware of, and I don't think the court has either. I'd ask that the court consider a PR bond. Obviously, I don't think he's had any sort of criminal charges pop up in the last time. The delay in timelines is certainly no fault of his own. It doesn't seem like we're maybe in any.
I don't have a problem with the PR. What I'm struggling with is no contact provision.
You know,
so that's either going to put him or his son out of his house.
I think that I think that a bond provision doesn't necessarily have to be a strict no contact, but I do think that the court could order as a bond provision no threatening or assaultive behavior, and if there was, that would constitute grounds for an additional penalty at the very least, as far as civil contempt goes. And if the gentleman's promising to abide by any bond conditions, if you told him that, and emphasize that if there was any sort of misbehavior during the pendency of the case towards him and the alleged victim, that there would be some contempt to answer for.
You've got a T-shirt on, which is a ironic twist on AC/DC. It says ADHD. Is that one of your diagnoses?
Yes, sir. I have ADHD. Yes, I'm on medication. I take Prozac and Restorol.
Are you on supervision from Pivotal?
Yes, sir.
All right, I'm going to also order that you continue with mental health treatment and take all meds as prescribed. This wasn't a very pleasant report to read. You lost your temper at Burger King. But CPS has been involved and closed their case, left everybody in the same house. A year passed. Nobody ever bothered to serve this warrant. So I tend to agree with Mr. Stickley, the public defender. I'm going to set the bond at $500 PR. There is not a no contact provision. So you're allowed to live in your home, but you're not to discuss this case with your son. You're not to have any weapons or firearms, no assaultive or threatening behavior, and no drugs and no alcohol. You're also to continue with your mental health treatment, take all medications as prescribed. So you should be bonded out a little bit later this afternoon. You've got somebody that will come get you.
I have no money. I gave my money to my spouse for a mortgage payment.
Well, will your wife or somebody come get you?
I haven't. When I got arrested, I haven't spoken with nobody. I'm kind of embarrassed about this. I can call and see if they will pick me up. Yes.
Well, I don't. If you need, you could get a bus pass here at the courthouse. But it's a nice day. It's a long walk from Centerville to South Hooker Street.
I'd probably walk the 616 Youngman Road, just so, I mean, I don't want to have, I know how I can get and I know how I am now. I want to kind of just be around my mother, just so I don't, not around my son, just in case anything gets mentioned. Not that we don't have no animosity in the house anymore, but I haven't been at my home in a week.
All right. Well, that's up to you. You'll be released. You're not prohibited from going there, but if you go to Youngman Road, that's certainly okay too. All right. Remember to repeat: no drugs, no alcohol, no assaultive behavior, no weapons or firearms. Continue with mental health treatment and take all medications as prescribed. And your next court date will be June 20th at 8:30, and we will appoint an attorney for you. Can you still get your mail at the Hooker Street?
Yes, sir.
All right. You're good to go.
Thank you.
Hooker Street was named after the general, not a house of ill repute. For a historical lesson. You're good to go, sir. You can go out and we'll bring our next person in. All right, good luck. There's a little more going on there, and I think maybe it's probably is safer if he goes out to Youngman Road.
Did we lose the jail?
I put him in the waiting room. Shayna, what happened to Stephen Stockwell? He was on the list this morning. I don't have that file now. Is he somebody I need to see?
I never got the complaint from the prosecutors.
Okay. How long has he been in there? We're struggling to get the complaints because they're struggling with the staffing. He's not even on my list. Just abandoned out or escaped. Are they?
Hello?
Hello. Are you Destiny Ford Morse?
Yes, I am.
We haven't met. I'm Judge Middleton. With me is Mr. Keith Stickley. He's the Chief Public Defender for St. Joe County. You managed to get yourself arrested on a 6-year-old drinking driving charge. Let's talk about that. The file number here is 192067SD. The ticket says that on July 25th of 2019 at 2:43 a.m., you got pulled over at US 131 and Riverside Drive in Constantine Township. Your blood alcohol was 0.108. They also alleged you had open intoxicants in the car. They gave you an appearance date of August 12th, 2019 at 8:15 a.m. You did not appear. You sent us an email that said, I've been having difficulties. My car got repoed. Could we please have another date? You didn't show up on Monday, August 12th as the ticket directed. So they gave you another date back in the summer of 2019. And then you didn't show up for that either. So somebody, I think, must have, let's take a look. Judge Pattison issued a bench warrant. They adjourned it to September 18th. He didn't show up on September 18th, so Judge Pattison issued a warrant for your arrest. So that warrant has been out for 6 years. We have a long memory around here. And apparently you recently got arrested in Hillsdale County, Michigan, and they brought you here from Hillsdale. Is that correct?
That is correct, but I reached out by writing a couple of letters to you to try to get this warrant taken care of.
Well, let me see. I don't see him in the file here, but this is, you wrote the letters to me, Judge Middleton?
I wrote them to the court. I wrote 2 letters.
I don't disbelieve you, but I don't see, wait a minute. Well, you got arrested in Hillsdale in December of 24. Is that true?
Yes.
Resisting an arrest and some fraud. What happened to your Hillsdale charges? Are they done?
No, I'm there until on January 15th. I'm on loan from them to you. That's why I thought I was brought here was due to the letters that I had been sending, trying to get this matter taken care of while I was there.
Yes, you did. And so we issued a writ of habeas corpus and brought you over here. So otherwise you would have had to wait till January to deal with it. So I'm going to Mr. George would be the attorney appointed, but he's not available on May 30th, and I'm not going to wait all the way till June to deal with this. I'm going to show the defendant pled not guilty. So have you been sentenced in Hillsdale?
Yes, Your Honor. I'm there till January 15th.
All right, we'll get this taken care of while you're here. I'm going to show a plea of not guilty. I'm going to appoint an attorney, set an attorney pretrial for, I don't even want to go that far. Well, you got to be somewhere because you're not going to get out from May 30th at 8:30. Appoint an attorney, not Tim George. I'd really like to know where you've been for the last 6 years, but I don't want to get into that now. You're here, you're obviously sober and clear-headed, but we'll get an attorney and see if we can get this resolved on or before. Your blood alcohol was 0.108, and I didn't see that you had any priors. This is a type of case they probably would have reduced to impaired driving. And today is the 14th. That's 16 more days before we have our next court hearing. I'm going to see if I can somehow move that up. Get you back to Hillsdale. Are you in any programs or anything at Hillsdale?
In Hillsdale, I am taking advantage of the NA classes that they offer when they're available. But other than that, just self-study.
Now, when you were here, you were living in Osceola, Indiana, back in 2019. Where do you live now?
I still live close to there in South Bend, Indiana. And actually, when I leave Hillsdale, I go back to incarceration in Indiana, where there I'm in a program. I'm purposefully incarcerated in Indiana. So that's the program that I'll be doing when I go back.
That's out of St. Joseph County, Indiana?
Yes, Your Honor.
You guys can leave.
All right, and what are the Indiana charges?
The Indiana charges were fraud on a financial institution and synthetic identity deception.
All right, looks like similar to that. You had a fraud years and years ago. I'm not trying to be unkind here, but this sounds like methamphetamine got in the way and jumbled up your life. I'm not sure if I'm in the right ballpark or not, but But this old case will get it resolved. Yes, you did write to us, which caused, I'm not sure who did it, Judge Pattison, I think, but did a writ of habeas corpus to bring you over here and deal with it now rather than wait till January. So we often do that. So I guess you're stuck with our hospitality for a while. The bond was originally $500 cash or surety. I'm just gonna leave it at there. You're not gonna bond out anyway.
Your Honor, they had told me when they picked me up yesterday that I was only staying overnight. They, wasn't able to bring any of my things. My cell was left
Oh,
unpacked.
well, all
and-
right. Then maybe they're gonna take you back. They can take you back and bring you back again on May 30th, I guess.
Okay,
It's okay with me. Hillsdale's jail is very crowded. They probably like to leave you over here. But you've been arraigned, you pled not guilty. I appointed an attorney, left your bond at $500 cash or surety. Your next hearing is May 30th at 8:30. And if they take you back, that's fine with me. You've got your situation over there. This is very likely to be resolved if you're willing to enter some sort of a plea. It'll simply probably be just closed out and you'll go take care of your other problems. All right, do you have any questions?
no, Your Honor, I believe that's all.
All right, you're good to go.
Thank you.
All right, so I think I'm swinging in the right ballpark. I think drugs came in and turned her life upside down. Anyway, if she goes back, that's fine. Hillsdale's not too far. You go over there a lot back and forth. Maybe you could give her a ride and
Or not.
bring her back. Bring her back. She plans to return to Hillsdale jail. They did list one more arraignment, Mr. Stephen Stockwell on a domestic violence. I don't show him as being in our jail, and I don't have a complaint, and they don't have any paperwork, so I guess we're not gonna deal with him. But thanks for your help. We did take care of 5 cases.
Wait a minute. Didn't we have, hang on a minute. Harold
Abel, he's the first
Richie,
guy. I gave him
yeah.
PR bump.
Smith,
Destiny,
Ray,
Ford, Trampus,
yeah,
Richie.
okay, no, I guess we got it. Okay, I thought we had 6, sorry.
All right, we had 6, but Stockwell got taken off the board.
All right.
All right, thanks. I'll
Yep,
see you tomorrow.
Yep.
You don't have you do have arraignments tomorrow, according to Jeanette. She was happy you were gonna be back tomorrow.
I will be back. I will be back
We
tomorrow.
have 20 misdemeanor arraignments. They're almost all driving suspended, no ops, no insurance. I think the great majority of them are traffic matters, and they're doubled up because they put last Thursday and tomorrow on the same day. But
Well, I'll get here early and ask for a special dispensation to bring a giant coffee. We'll get through it.
okay, I'll be here. Thank you.
Bye.
All right, that finishes our abbreviated day.